Chairs, Councillor Patrick O'Leary, and I'll pass it over to you.
Let's hear that a second.
Oh, sorry, Susie, I think your mic's still on. No worries. Thank you. Do you need me to quickly forward over to you?
No, I do apologise for the delay.
That's the sense of tension, Patrick, really, doesn't it?
I'm sorry?
That's the sense of tension.
Right, my apologies for the delay. So good morning and welcome to this meeting of the licensing panel. I'm Councillor Patrick O'Leary and Councillors Ron Batstone and Oliver Forder will join me today on the panel. I have a few statements to make before we proceed with the meeting. Please, can everyone ensure that all mobile telephones and any other devices are switched to silent during the meeting? In the event of a fire, the Democratic Services Officer will lead attendees outside the building where they should remain until directed to return. The meeting will resume once all attendees have returned to the meeting room and are ready to continue. If you have a question to ask in the meeting, you should raise your hand to alert me. Please do not speak unless invited to do so, and please do not interrupt other speakers. For those joining remotely, when you are not speaking, please ensure your microphone is muted and your camera is turned on. Are there any questions on this or any other issue which requires addressing? Okay. The procedure for this meeting was included in the agenda pack. Could I ask if everyone has understood the procedure that would be followed, or does anyone have any questions they wish to ask at this stage? Thank you. Application for the review of premises license, Gold Star off license, Ox Street, Abington. I will now begin this item and I invite the licensing officer to present the report.
Sorry to interrupt, but can we just check there's no declarations of interest just before we proceed, if that's okay?
Oh, I do apologise. Absolutely, okay. Don't turn it on here. So anyway, if there is any conflict of interest and what have you, please so at this stage. Okay.
Okay, perfect. Thank you. Sorry for interrupting.
No, not at all. Not at all. So, the licensing officer.
Chair, the application before this panel today is for a review of the premises licence for Shop Smart Enterprise Limited, trading as Gold Star off licence at 256 Ox Street, Abingdon. The application was submitted by Russell Sharland on behalf of Oxfordshire County Council Trading Standards. A copy of the application is in your pack, starting at Appendix A from page 18. The grounds for the application are set out in the report, however, I will summarise for the panel today. The application sets out that there were 4 visits to the premises. This included covert test purchase operations and an announced inspection. All 4 visits uncovered illegal items such as disposable electronic cigarettes, hand rolling tobacco and cigarettes. Prior to these visits, the designated premises supervisor, who is the sole director of the limited company that holds the premises licence, received a detailed written and verbal advice following seizure of 748 illegal electronic cigarettes from the premises on the 4th of July 2023. There has also been 4 intelligence reports received between October 21 and January 24, alleging the sale of illegal electronic cigarettes and sales of these age-restricted products to people under 18. The applicant is Russell Sharland, who is located directly opposite me. He is Trading Standards Tobacco Control Officer at Oxfordshire County Council. He is accompanied by his colleagues William Gordon Roach, with the white shirt on, and Evangeline Davidson, lady opposite me. We also have in attendance John Reader, who is the sole director of the shop, ShopSmart Enterprise Limited. He's also the holder of the premises license and the designated premises supervisor for the premises. He's located directly opposite me as well. He is today represented by Mr. John Payne from Licensing Lawyers. During the consultation period, the application receives 2 representations. A copy of these representations are attached in your report pack from Appendix D, starting on page 94. These representations were submitted by Richard French, Licensing Enforcement Officer, on behalf of the Licensing Authority. He is located at the end of the desk over there. And Mr. Andre Silva, who is a local resident submitting representation in support of the premises. He is not in attendance today. The attention of all is directed to the Council's licensing policy, which sets out how the Council will deal with applications, and also the relevant parts of the Secretary of State's guidance for which the Council must have regard when carrying out its licensing functions. I can confirm that the application was advertised in accordance with the Licensing Act hearings regulations. The panel is requested to consider this application for review of the premises license and decide whether you want to modify the conditions of the license, to exclude the licensable activities from the scope of the license, to remove the designated premises supervisor, to suspend the license for a period not exceeding 3 months, or to revoke the license. I have nothing further to add at this point.
Thank you. Thank you for presenting the report, and I'll invite panel members to ask any questions they may have to the licensing officer.
Yes, actually, I just want to get the timeline clear in my own mind here. There were various transgressions, we understand, before the advice was given. Were there transgressions after the premises had been visited and the advice had been given? Sorry.
Just clarify which transgressions you're.
Well, you said that there were a number of sales of illegal cigarettes and everything like that.
Yeah.
And I think it was in 2023 that the
Yeah, so they
premises was
received the
visited.
warnings, and then the 4 visits were in this year, so March, February this year.
So have there been transgressions of sales of non-permitted items after the detailed advice was given to the
Yes, so the detailed advice was given in July 23.
Yeah.
And then the visits this year were in March this year.
Okay. And you also said that there were 4 pieces of information given by third parties. Have any of those been held to be proven, or are they simply allegations?
Those are not questions for me, those
Yeah.
are questions for Trading Standards, who submitted the application.
Who are the
Okay,
applicants?
Thank you very much.
Does any attending party have any questions for the officer? Okay. If there are no further questions, I'll now invite the applicant to present their case.
Good afternoon, and thank you for hearing our application today. So this review has been brought due to evidence that the licensed premises has been used to sell and store illegal tobacco and also illegal electronic cigarettes in breach of the licensing objectives. What you've read in the review application about the sales and storage of these products constitutes alleged criminal offences. There is an ongoing and parallel criminal investigation which may lead to prosecution. However, and this is an important point, this review is not about determining the guilt or innocence of any individual. It is simply to ensure the promotion of the licensing objectives. This review includes grounds that the premises has been used for criminal purposes. In line with the statutory guidance, the goal of the review is to determine what steps should be taken for the promotion of the crime prevention objective. I'd like to begin with the issue of the illegal tobacco. Illegal tobacco is a catch-all term which includes cigarettes and hand rolling tobacco. There are different types of illegal tobacco, including smuggled and counterfeit, which both feature in this review. Smuggled refers to legally manufactured product for sale in another country that then has been illegally brought here without the required UK duty being paid. Put simply, the tax has been evaded. It therefore tends to be significantly cheaper, and depending on the country of origin, the warning label is often in a foreign language and may not comply with the UK's plain packaging laws. Counterfeit, on the other hand, refers to a tobacco product that hasn't been legally manufactured. It's masquerading as a genuine product, but in fact, a customer would have no idea where it was actually made or what it really consists of. Like smuggled product, UK duty is avoided, and so they are significantly cheaper to purchase. So why is this a problem? The severe health risks associated with smoking have been widely reported and accepted. Smoking costs the NHS approximately £2 billion a year for treatments. One of the key drivers to reduce smoking prevalence has been the tobacco duty rates. Cheap illegal tobacco can undermine the efforts of a smoker to quit because it keeps smoking affordable, and its ready availability may also encourage some to smoke more than they otherwise would. In addition, while there's no such thing as safe tobacco, counterfeit versions are unregulated, and unlike the legal product, their true content is unknown. The seriousness is reflected in the Secretary of State's guidance. At paragraph 11.27 of the guidance, it states, there is certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously. The list includes the use of the licensed premises for the sale or storage of smuggled tobacco. That sets out the context for this review. On the 9th of March of this year, a trainee trading standards officer was in the premises when a customer asked for a pack of Golden Virginia hand rolling tobacco. The man behind the counter said he had Golden Virginia cheaper if the customer wanted it. He pulled out the small, tied up blue plastic bag from behind the counter. He showed the customer a pack which was not in the required plain packaging. He said to the customer, it's the same, but cheaper. I can do it cheaper for you. The customer agreed, and he made the sale. At page 33 to 34 of the pack, these facts are set out in the officer's witness statement. This, we say, is evidence of the licensed premises being used for the sale and storage of smuggled tobacco. On the 15th of March, 6 days later, a trading standards officer made a test purchase of a 50-gram pouch of smuggled Golden Virginia hand rolling tobacco for £25 that was not in plain packaging. The warning labelling was in Spanish, and this was smuggled product. The lawful version of this product currently retails in major supermarkets for over £38, so a £13 difference. And if I can ask you to turn to page 35, you can see how clearly this is distinguishable from the UK equivalent. This, we say, is further evidence of the licensed premises being used for the sale and storage of smuggled tobacco. Later that same day, officers conducted an announced visit at the premises and were assisted by a detection dog. Before the inspection commenced, the sole person in charge of the premises, Mr. Solomon, was asked if there were any other tobacco products in the shop other than the usual legal ones in the gantry and drawers. He presented a plastic bag contained within another plastic bag, which held 4 unit packs of illegal amber leaf tobacco and 1 unit pack of illegal Golden Virginia tobacco. It did not indicate anything further than these items. The detection dog identified more illegal tobacco stored in the counter area, consisting of a blue plastic bag containing 4 unit packs of Marlboro Gold cigarettes. The inspection continued and further illegal tobacco products were identified in the storeroom, namely 15 unit packs of illegal amber leaf tobacco. And if I can ask you to turn first to page 53. This shows the Marlboro Gold cigarettes, labelled in Polish and not in plain packaging. Again, this is easily distinguishable from the legal version. And if you can then turn to page 54 to 56, this shows the smuggled tobacco, the Golden Virginia labelled in Spanish, and the amber leaf not stamped with UK duty paid. And finally, if you could turn to page 57 and 58, these are the counterfeit amber leaf products, masquerading as the legal version, but with telltale mistakes. On page 58, you'll see the item is marked duty paid, whereas it should be UK duty paid. And you'll also see incorrect website address missing the .uk. I've circled them in red. A total of 20 unit packs of illegal tobacco and 4 unit packs of illegal cigarettes were seized. On page 59, there is a table, there's a breakdown of what was seized and where it was located. On page 60, the photograph shows where the tobacco was found in the storeroom, circled in red. During the course of the inspection, an officer spoke on the phone to Mr. Reader. During this conversation, he made the unsolicited comment that the products were for personal use. Although this is contradicted by the evidence, this appears to be an admission from Mr. Reader that the premises was knowingly being used to store smuggled tobacco. Mr. Reader was subsequently interviewed under caution. He said the cigarettes were purchased for his personal use. The hand rolling tobacco was purchased for an unnamed friend. All the items were purchased from a Romanian or Polish male who came to the shop 1 to 2 days before the seizure on the 15th of March. And the person was not previously known to him, and he did not have their contact details. Pausing there, the evidence of Officer Davidson that she observed the sale of smuggled Golden Virginia tobacco on the 9th of March contradicts Mr. Reader's version of events. Mr. Reader went on to say that he had instructed Mr. Solomon not to sell any of these products. And when the evidence of Officer Davidson was disclosed, said, "I don't believe it." He reaffirmed that those items were never sold. When challenged that Officer Davidson's evidence was from 9th of March, contradicting his explanation that the items had been purchased 1 to 2 days before 15th of March, he again responded by saying, "I don't believe it," and "I never sell it." When the details of the evidence of the test purchase made by the officer on the 15th of March was disclosed, he responded by saying it must have been a mistake by Mr. Solomon due to language difficulties. Chair, as you've heard, Officer Davidson has provided a witness statement with a signed declaration. She has no reason to lie and nothing to gain by doing so. She attends today ready to answer any questions you may have in relation to her evidence. You've heard that the tobacco products were not stored together in one bag, but were separated and were in different locations. And you've seen the photographs from the storeroom. We pose the following questions. Why are they there? Why are they spread about different locations if they were bought at the same time from the same source? Why weren't they simply taken home by Mr. Reader? These more recent instances are not the first time this premises has caused concern to trading standards. Now we turn to the issue of illegal electronic cigarettes. Electronic cigarettes, or vapes, were designed as a tool to help smokers quit. They provide the user with a way of inhaling nicotine without smoking carcinogenic tobacco. But their use has become such a concern that following consultation, the government announced in February their intention to ban disposable electronic cigarettes, explaining that they have been, quote, a key driver behind the alarming rise in youth vaping, with a proportion of 11 to 17-year-old vapers using disposables increasing almost ninefold in the last 2 years. On the 4th of July last year, as you've heard, 748 illegal electronic cigarettes were identified and seized from the premises. This is a very large amount to be seized from one shop. On that occasion, it was dealt with by advice and final warning. A detailed letter was sent to Mr. Reader dated the 10th of July last year, which states, on this occasion, this authority does not intend to take formal action and is willing to work with you so that you understand the law on the strict proviso that no non-compliant products may be supplied by you at retail. In addition, your premises will be visited again in the future to assess compliance. If further breaches of the above legislation are detected, it is unlikely that a lenient approach will be taken again. If I can ask you now to turn to page 76. Mr. Reader signed a form acknowledging the written advice he had received, and that he understood he would be criminally liable for continuing to sell illegal electronic cigarettes again. We say this was fair, consistent with a staged approach to compliance, and the warning was clear and unambiguous. On the 9th of February of this year, an enforcement assistant officer made a test purchase of a lemon and lime flavoured disposable electronic cigarette, which contained 18 millilitres of nicotine liquid, whereas the legal limit is 2 millilitres. So this was 9 times the legal maximum allowed. The officer was taken to a rear storeroom and shown a selection to choose from that were contained in 2 bags. In his interview, Mr. Reader denied that happened. As before, the officer is with me today and is available to answer any questions you may have. He has provided a witness statement with a signed declaration. On the 15th of March inspection that you've already heard about, 39 illegal electronic cigarettes were also seized. A further 32 electronic cigarettes were labelled as 0% nicotine, but it was noted that some showed a 2% nicotine label when the 0% one was peeled away, and so those were also seized. In his interview, Mr. Reader said he had trained Mr. Solomon on age-restricted products, but not on illegal electronic cigarettes, and did not keep any record of his training in any case. He acknowledged the previous seizure of 748 illegal vapes last year. He explained that the illegal vapes seized in the storeroom in March had been kept there since July last year, waiting for the supplier to return to collect them. He repeated several times that these items were not for sale. As you've heard, between the 11th of October 2021 and the 5th of January 2024, 4 anonymous relevant intelligence reports were received alleging the premises was selling illegal electronic cigarettes and selling them to persons under the age of 18. After this review was submitted, a further anonymous intelligence report was received, which included an allegation that the premises were selling vapes and alcohol to children. For completion and fairness, the premises passed an underage sales test purchase attempt of electronic cigarettes, which took place on the 9th of March 2024. Since the second seizure, the premises has also declined to sell illegal tobacco or electronic cigarettes at further adult test purchase operations on the 30th of March. However, the test purchaser was told, no brother, we stopped in relation to the electronic cigarette request. As you've heard, the guidance regards using a licensed premises to sell or store smuggled tobacco to be a criminal activity that should be treated particularly seriously. At paragraph 11.28, it states, where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the license, even in the first instance, should be seriously considered. There's also decided case law to assist, which is included in full at page 79. In our Bassett Law District Council v Worsops Magistrates Court, it was found that deterrence is an appropriate consideration in reviews such as this one. The sale of illegal tobacco products are regarded as serial criminal offences and are given particular prominence within the guidance. Notwithstanding the public health issues you've already heard about, they are sold at prices well below the legally compliant versions, giving premises doing so a commercial advantage over their competitors that trade legally. The Trading Standards Service regards the failure to heed detailed previous advice as an aggravating factor of particular concern. Given the statutory guidance and supporting precedent, it's the recommendation of this service that revoking the premises licence should indeed be strongly considered. If revocation is strongly considered but not deemed appropriate on this occasion, it's recommended that a period of suspension of up to 12 weeks and the addition of conditions would act as a necessary deterrent to promote the crime prevention objective and to protect the needs of the wider community. We've suggested a number of conditions that are laid out in the application. Mr. Payne and I have already been in discussion regarding these, and although we have some disagreements on the wording, I think we both agree on the general principles. That concludes the representation, unless I or any of my colleagues can assist you further.
Okay. Now, if any attending party wishes to speak, please raise your hand now, and I will proceed through each speaker who has indicated they wish to make a verbal
At
statement.
this stage, it's
Have I jumped over one?
questions to-
Okay, the applicant's case.
So you will have an
That's
opportunity
right,
to ask
my
questions. and then
apologies.
we'll turn to
Right,
the-
the applicants. Thank you. And I invite the applicant who has requested this review. Sorry, that's it. Panel members to ask questions of the applicant. Okay.
Yeah.
Oliver, any questions here?
Not a question, but I just wanted to say that the question that I attempted to ask the licensing officer, you've fully answered in your presentation. Thank you very much.
I've got any questions at this stage?
Does the license holder have any questions for the applicant?
Chair, no, thank you.
Does the licensing officer have any questions for the applicant? Thank you. If any attendant party wishes to speak, please raise your hand now, and I will proceed through each speaker who has indicated they wish to make a verbal statement. Do members have any questions for the speaker?
Chair, are you addressing
Yeah.
that to those that have
Yeah.
made representations?
We've actually got the licensing officer here who I'm anticipating will wish to make a presentation. So
Well, you can, obviously you can go to the premise license holder first and then me, or me first and then the
Yeah,
premise
right,
license holder.
yes.
I don't think Mr. Payne's to.
what would
I'm content either way. It makes sense to hear what are effectively representations for or in favour of the application to go first. You've got one representation who is for us, if I can put it like that, who isn't here today. So that won't happen. I would suggest that Mr. French goes next, and then we come to us to hear what we have to say.
I think that's certainly the logical way.
Yes, thank you.
Proceed. Thank you, Chair. The licensing authority in its role as a named responsible authority, obviously licensing has two hats in the Licensing Act, fully support the review and the requested outcome of, it's already been outlined by Mr. Sharland, that is the revocation of the premises license. Whilst I'm not going to repeat everything that Mr. Sharland has said, because he's very eloquently laid it all out for you. I would just like to note that paragraph 51 of the Licensing Act states that we are reviewing the premises license, we're not reviewing the premises license holder, as opposed to taxi licensing where we're deciding if somebody's fit and proper or not. That's not the case in this instance. Fortunately then, given that we are focusing on the review and not the separate criminal investigation, I would suggest from reading the review that there aren't really many facts in dispute in relation to what's in your pack. As already pointed out by Mr. Sharland, the Secretary of State's guidance at 11.27 has a list of 11 specific offences which are deemed particularly seriously. One of them is the sale or storage of smuggled tobacco, as Mr. Sharland has already outlined. And then it goes on at 11.28 to state that revocation, even in the first instance, should be seriously considered. I would also note that the sale or storage of smuggled tobacco and alcohol is actually a criminal offence within the Licensing Act itself, at paragraph 144. So they obviously envisaged that this may be an issue back when they were drafting the Licensing Act in 2003. So just focusing on the illegal tobacco, and as Mr. Sharland has already outlined, there are witness statements on pages 33 and 34 detailing the events of the 9th of March. And as Mr. Sharland has already outlined, the member of staff, unprompted, opens a bag behind the till and offers a customer a packet of Golden Virginia tobacco. So it wasn't a member of the public coming in asking for smuggled tobacco, it was just offered up. Obviously that was witnessed. And then Mr. Sharland has already outlined the test purchase for the same product, which was made 6 days later on the 15th of March, retailing £13 lower than when it sells for in the major supermarkets, which obviously undercuts legitimate businesses in Abingdon who don't try and sell smuggled or counterfeit tobacco. And as Mr. Sharland has already directed the panel to page 35 of that packet, which was smuggled. The panel's already been appraised of the following sniffer dog operation on the afternoon of the 15th of March. The staff member was asked whether there were any tobacco products other than in the gantry or the drawer, and immediately presented one plastic bag containing illicit tobacco products. However, no further products were offered up or mentioned. And then training standards officers, with the assistance of the dog, were able to locate other illegal Marlboro Gold cigarettes behind the counter and further illegal tobacco products in the storeroom. So I won't go into any more detail about that because Mr. Sharland has already outlined that. So put simply, is the sale or storage of illegal tobacco and cigarettes a serious criminal offence? Yes, as per the Act and per the guidance. Were they sold on the premises? Yes, and knowingly on the 9th of March, when the member of staff offered them up to the customer, and yes, on the 15th of March in a subsequent test purchase. Were they stored on the premises? Yes, behind the counter and in the storeroom. Did the premises licence holder purchase them? Yes. I refer the panel to paragraph 12 on page 22. Mr. Reader's responsive, as Mr. Sharland has already outlined. Is Mr. Reader the sole director of Shop Smart Enterprise Limited? Yes. Therefore, what is described in the paperwork, the witness statements, and Mr. Reader's own admissions would both engage the sections of the Secretary of State's guidance that Mr. Sharland and now I have referred to, and the offence of section 144 of the Licensing Act, which severely undermines the licensing objectives, notably the prevention of crime and disorder. I'm just going to touch on the illegal vapes, because I say illegal vapes are still a bit of a, in terms of content and whatnot, still a bit of a mystery to me in terms of what they actually are, what they do. But the selling of illegal vapes, as Mr. Sharland has already outlined, has gained prominence nationally over the last few years. I think what is particularly egregious in this, and what's been outlined in this case, is the seizure of illegal vapes on the 15th of March 2024 followed a previous seizure on the 4th of July 2023 of 748 illegal vapes, which is, should we say, rather a large amount. And it is clear that these would not have come from legitimate suppliers or wholesalers. I would draw the panel's attention again to the letter that Mr. Sharland has already referred you to on pages 62 and 62 to 67, which is the letter sent out by Oxfordshire County Council Trading Standards after the first seizure, because that is one of the most detailed advice letters I think I've ever seen sent out by any regulatory body, and it's quite clear of the consequences should further offences be located. That stepped approach, again, Mr. Sharland mentioned, is consistent with paragraph 11.10 of the Secretary of State's guidance to the Licensing Act, which advises giving licence holders warning of concerns and the steps they need to rectify those issues to head towards compliance. You'll note on page 76 that Mr. Reader signed that acknowledgement form, and where he acknowledges receipt of the written advice he has received and acknowledges that continuing to sell such products as outlined constitutes a criminal offence for which he would be liable. Unfortunately, that advice seems to have not been heeded, and Mr. Sharman has already outlined for you the failed test purchase in relation to a vape on the 9th of February and the witness statements being produced on pages 29 and 30 in relation to that. Obviously concerning that it's when the test purchaser returns the premises on that day, on the 9th of February, to return a vape. He was taken to the storeroom and was offered ones from a plastic bag. So I think it is clear just from that angle, the tobacco and the vapes, that Trading Standards colleagues have tried to work with the premises as far back as July 2023. And this clearly has not been heeded given the failures in 2024. The Secretary of State's guidance at paragraph 11.18 in your report clearly states that when a responsible authority, such as Trading Standards, have already issued warnings and set out what needs to improve, which have failed or not been heeded, that the licensing authority, when determining a course of action, for example, during this review, should not repeat that approach, and also take into account the fact that the warnings have not been heeded when determining what action to take to promote for licensing objectives. If I can just touch on the licensing issues that the licensing authority representation makes reference to, and that is at the end of your pack on pages 94 to 104. Being granted a premises license is a privilege, and licence holders are expected to promote the four licensing objectives in everything that they do at the premises. This is particularly important in respect of the sale of any age-restricted good or product. You would expect, and we would expect, given it is set out in the Council's licensing policy, licence holders to implement robust measures to ensure that criminal offences do not take place at the premises. Products like alcohol and tobacco are purchased from legitimate supply chains, and that age-restricted products are not sold to underage persons by any staff member. To protect their own business when they're away, for example, you would expect that they would train their staff in what is expected of them and what the premises age verification policies are in respect of all age-restricted products. I refer to the letters sent by the licensing authority to the premises licence holder on page 99 through to 103. To point out to the panel that no response has ever been received in relation to either of those letters from Mr. Reader or anybody else. Indeed, the only response that has been noted was the additional material, I believe, served by Mr. Payne last week, which consisted of some photos and some other documentation. The staff member on site during both inspections could not locate the licence, could not locate the mandatory section 57 notice, which would have told him where the licence was, could not demonstrate how or by whom he had been authorised to sell alcohol, could produce no written training record. A book was being used, which was alleged to have been a refusal book, but contained very little information that it was virtually useless. No fire risk assessment for the premises could be produced as well. The contents of the inspections and required actions were relayed to Mr. Reader verbally at the time and in the subsequent letter. No response has ever been received, as I've just mentioned. Usually we would expect to see all of the matters raised in the first letter rectified so as to avoid a repeat. This also shows that we as a licensing authority are willing to work with licence holders and give them time to take corrective actions when non-compliance is discovered. Therefore, our approach mirrors exactly that taken by our trading standards colleagues. Again, the advice and letters detailing what corrective action was required have not been heeded. If licence holders do not wish to or fail to engage with the process, then as I mentioned earlier, paragraph 11.18 of the Secretary of State's guidance states that that process should not just be repeated. The panel will also note from the first letter dated the 4th of July 2023 that the licensing officer was informed that the designated premises supervisor, i.e. the person with alleged day-to-day control of the premises and usually the person who authorises the sale of alcohol, had left the premises and no longer worked for the business. It was not confirmed either at the time or since when that had happened, but that does raise concerns about who was authorising the sale of alcohol and whether the mandatory conditions attached to the licence stating that no alcohol can be sold at a time when there is no DPS were being complied with. Mr. Reader transferred the premises licence into his name in January 2022 from the same person who was stated as the DPS who had allegedly left the premises. So between January 2022 and the 7th of July 2023, it is not clear whether there was any DPS on the premises at all authorising the sale of alcohol. I would suggest that it is clear that the premise licence holder has done little in the way to promote the 4 licensing objectives, has a poor compliance record and has done little to engage with any of the regulatory bodies such as ourselves and trading standards. It is the same pattern across dealings with both regulatory bodies. Advice and warnings are not heeded. The urgent need for corrective action has not been taken, and even communicating after receipt of those advice and warnings has been non-existent. This only undermines public safety for people who use the shop that the licence holder is unwilling or unable to comply with what is expected of him. I just want to touch on the last page of the representation submitted by the licensing authority, which was the food rating from the Food Standards Agency, and that's on 104. The only purpose for the inclusion of that was once again to show that the premises licence holder is not complying with his regulatory responsibilities, given that the premises was issued with a 1-star rating with major improvement deemed necessary. You'll see in the breakdown of the 3 categories, which is only a summary, that is the management of food safety, which is of particular concern. The management of food safety covers systems or checks to make sure that food is sold or served safely, evidence that staff know about food safety, i.e. staff training, and whether the food safety officer has confidence that those standards will be maintained. For completion, I do understand that a re-inspection has been carried out in recent weeks where some improvements have been made to this. However, the point still remains that a regulatory body, this time Environmental Health, has found serious compliance issues in a licensed premises which the premise licence holder has allowed to occur. Finally, I just want to touch on concerns around the licence holder and the responses that have been given to officers. The panel will note from the second paragraph of the second licensing inspection letter, starting on page 101, that both Mr. Reader and his employee, Mr. Solomon, stated numerous times during that inspection that Mr. Solomon had only been working at the premises for 8 days. That is clearly not true, and I refer the panel to the page 21, where the same individual was encountered on the 15th of March 2024. The worker makes a similar statement on the previous inspection to being a trainee, or on the previous visit to being a trainee. It is unclear what the dynamic or relationship is between Mr. Reader and Mr. Solomon, but at the very least, the answers in relation to Mr. Solomon's employment given by Mr. Reader are factually inaccurate and contradicted by the available evidence. And I'd refer the panel again to Mr. Reader's responses in the review paperwork. To conclude, the licensing authority in its role as a responsible authority fully supports the review submitted by the Trading Standards Service and their request for the premises licence to be revoked. The alleged criminal activity that has taken place in respect of illegal tobacco, cigarettes and vapes is clearly documented within the review, has taken place on a licensed premises repeatedly. It's not a one-off, it's a repeated issue, and undermines the promotion of the licensing objectives, undermines public safety, and engages the parts of the Secretary of State's guidance to which I referred to earlier. The failure of the licence holder to engage, even so far as not responding to letters, and the failure to ensure a basic level of compliance with trading standards law, licensing law, environmental health law, undermines the 4 licensing objectives. It is therefore the view of the licensing authority in its role as a responsible authority that the only appropriate and proportionate way to safeguard the public, the local community, and promote the 4 licensing objectives is for the premises licence to be revoked. Thank you.
Right, thank you. If any attendant party, wishes to speak, please raise your hand now.
I don't think we've got any other,
No.
any other parties. We've really only got the premises.
I'm allowed to ask a question.
That's the stage we've reached.
May I ask a question, please? Thank you very much for your presentation, Ms. Smedney. During the latter part of the presentation, you read out a lot of advice about the underage provision of goods. But please help me, are there any allegations of the provision of goods to underage people that have been made in this case?
There haven't been any allegations as far as I'm aware, but I think just as a basic principle of any licensed business, you would expect those processes to be in place. And as we saw, those processes aren't in place. So I think that was the point I was making. I'm not suggesting that, well, there's no test purchases of alcohol, for example, that have been done that I'm aware of, but you know, the process, there was no staff training, it wasn't clear who was authorising the sale of alcohol. The refusal book was not very good, to put it mildly. So those processes that you would expect an alcohol licensed business to be in place weren't in place.
Thank you very much, that's clear.
Yes, I think my question is, there aren't any, we've no evidence of any problems with alcohol in regards to selling alcohol to underage people.
We don't have any evidence of that, but as I said, so
It's the process.
it's the processes being in place and the fact that either Mr. Reader or the member of staff, there are no processes in place. And I think particular concern would be the training, which obviously Mr. Sharland alluded to in relation to the other age restricted products, and the DPS issue back on the original inspection of last year, where there didn't appear to be one. And obviously the DPS is generally the person who has day-to-day control and authorises the sale of alcohol. So in terms of actual, have there been any underage sales of alcohol? Not that I'm aware of.
Or any other criminal activity associated with alcohol, as far as we know.
Well, each breach of licence condition is a criminal offence. So, but in terms of selling those products, there's nothing that's come to our attention in relation.
Do you have any confidence in Mr. Reader to address now or in the future?
In a word, no. I think you've seen.
Certainly.
If you're asking, no, because as you've seen in your review paperwork, this doesn't just span licensing. This spans trading standards. This spans environmental health. And every time I believe Mr. Reader has been given an opportunity to rectify issues, because like we do want to work with business. We're not. It's not first striking you out or anything like that. But we do want to work with businesses. But if people fail to engage and then repeat the same behaviours later on, I don't think they can have any complaints when they're sort of sat in this arena and we're asking for what we're asking for.
Okay. Looking for the next one. Regards questions?
It's
Does the
Mr.
licensing officer-
No, it's
Yes.
Mr. Payne.
If I
has
tell
the
you attendant
opportunity
party
on
wishes to
behalf-
speak, please raise your hand now.
No, it's Mr. Payne on behalf of
Brilliant.
the premises holder to ask any questions of the licensing officer.
I'm sorry, I don't see it on here. My apologies.
No, it may maybe it's not
Yeah, I
made,
think-
but that is the.
I think Mr. Payne's going to ask both myself and Mr. Sharland some questions. I think that's right.
And I'm very keen to hear those questions and the answers to questions.
Yes.
Well, I'm actually going to only ask Mr. French one question, and that is whether the licensing authority has received a request from Johannes Haile Selassie to be removed as the designated premises supervisor before the license was transferred.
No.
Thank you. That was easy.
That's it, just one question.
That was easy, wasn't it?
It wasn't it? That's it, isn't it? So,
Big then.
okay, well, yeah, here we go, here we go. Right, would any other party who has spoken like to make a concluding statement summarising?
It's Mr. Payne's going on behalf of
Since he still hasn't spoken.
I'd quite like to go.
Yes.
Yes, if that's all right.
Apologies, I did got that mixed up. Please,
No, that's perfectly right.
please.
Chairman, the reason I asked that question about designated premises supervisor is very simple. And I just want to correct a number of points that perhaps have not exactly guided you down the right road in considering this application so far. The first point is with regards to the designated premises supervisor. Premises supervisor on the license is the premises supervisor until they resign or until they're removed. Neither has happened in this case. So to suggest that there has been an occasion where there has been no premises supervisor as required by the law on the license is wrong. Now, that it might be that person hasn't been at the premises for some time, but they are still the designated premises supervisor. The second point, and it's easy for anybody to make a mistake, and unfortunately, Mr. French has made a mistake in talking about the license because he talks about Mr. Reader transferring the license, quote, to his name or in his name. Mr. Reader is not the license holder. It's held by a company, and you will see that on the license. So those are two really important points to set the context and just to show regrettably that anybody can make a mistake. Indeed, you will hear that Mr. Reader has made some mistakes, and you've already heard that some mistakes have been made. Now, to address you on the points, and I think that I would echo, I think Mr. Sharland had said earlier, I know as Mr. French said earlier, that there is no disagreement on much of the evidence. Indeed, that's right. There is no suggestion that the Training Standards Department, Mr. Sharland, is making anything up in terms of what was found at the premises. There is no suggestion that these products were not on the premises. Quite clearly they were. And it is interesting, is it not, that when asked, the member of staff very openly said, here are the products that you're looking for. There was no intention to deceive, no intention to hide anything from the inspecting officers. So that has to be set in context. The other thing that has to be set in context is that in all of the evidence that you've heard, all of the purchasing that's occurred, all of the inspections that have occurred, where there have been what is more appropriately described as unlawful products or non-duty paid products, Mr. Reader himself has not been present. It's been somebody else that's been at the premises. Now, the reason I talk about non-duty paid products is because that's very different to smuggled products. Smuggled products are, of course, intending to avoid paying duty, whereas non-duty products are entirely lawful in this country if somebody brings them in, for example, for personal use. When you go abroad, you know you've got an allowance to bring back products from the European Union or indeed other parts of the country. So one has to be very careful about using these emotive terms, smuggled. Non-duty paid may be, but we will hear from Mr. Reader about those products that were on the premises and found in the premises. And you will have seen that all of those products that were on the premises were not secreted away in some little locked cupboard. I'm afraid I'm a bit old in the tooth and have done too many of these reviews with thousands of cigarettes being found in little locked cupboards under the floor, in the walls or whatever. That's not what happened here. These products were plainly on view in the storeroom. didn't really need a dog to go and find them. They were there as the photographs show, or indeed in a plastic bag underneath the counter. Now, Mr. Reader has given, I think it's on page 15, an account of what happened and the reasons for the products being on premises. It's probably helpful for me to let him have a chance to explain why those products were there, given that you have an outline already on page, I think it's 15, yes, of your papers, as to why they were there, who it was that sold them, and quite clearly from the evidence that you've heard already, it wasn't him. So, Mr. Reader, would you like to explain a little bit about what was found and why those tobacco? Let's deal with the tobacco problem.
Yeah,
Products first.
all right. Tobacco Bob just previous about they kept the visit and bought from one Polish guy, then he wrote another Polish guy, and then I bought him, and then my cigarette myself, I'm using it. And then the tobacco I bought from one of my friends. That's why when I had voluntary interview as well, I told them, Bernardo Solomon, even he has a problem language barrier, he been like in the country like 1 year and a half, you know, he doesn't understand that much. I told him, John said, even they don't know exactly who the cigarette is, each one on the shelf. So when they visit him, like they sold him, that's why the mistake happened. Even I had voluntary interview. They asked me the evidence, give me like one of your friends, you know, I've emailed them all the contact number, and his address as well, but they haven't contacted. But personally, cigarette, I'm using it myself, and the tobacco, so I'm bought with my friend.
Would you like to talk about the vapes as well?
Well, the vape, I mean, when the first time visits on the when they found 700 something, I don't have the knowledge, and I'm not bought from some car company that came here in the shop, and then I bought from some of them Southall, and then I've just waited him to pick up. I mean, I tried to phone him, doesn't come. So that's why when they visit the first time the shop, they've just seen it out. They didn't check in the store. Well, we have it. So that's why we left. I thought I'm gonna get my return back with some of my money. That's why I left. I didn't keep it. One second time when they can attempt to come, they didn't find it on the shelf. I keep it in the store. That with the supplier to come out was supposed to come some one day, then to pick up and to return my money. Yeah, that's what happened.
Chairman, councillors, the point has been suggested, and I say again in error, that Mr. Reader and company as the licence holder has not heeded the warnings. What we say is that that is not correct. It's something of a leap of faith to suggest that there has been no regard to what has been raised. It suggested there's been no response to the correspondence, for instance, that's been required. And you will see from the letter from the licensing officer, the final paragraph, one would expect that if the officer wanted contact, then they would say so in the final paragraph of the letter, page 96. If you have any questions in relation to the contents of this letter, please contact me. Only if you've got questions. Not come back to me and tell me that everything's been attended to, or I need you to confirm within 28 days. Now, Mr. Reader and the company runs a small shop. They have many things to attend to, and clearly if they've been required to go back, then the suggestion is that they would have responded to that. But in the absence of being required to, they've done all the other things they need to do to run the shop. Now, the other thing that has changed since this review application has been submitted is that the company has sought some professional advice. I'd like to think that my company offers some professional advice. And indeed, we have done that with this particular business. And as a result, there have been a number of changes. Now, some of those changes were not required as a result of any intervention that we made. For example, displaying the license. You have a photograph. I'm visiting the premises the other day. There is the premises license clearly on display. That was already done. age verification, there's a photograph which shows the age verification policy. And it's quite reassuring, is it not, that in the test purchasing, there have been no successful underage purchases of alcohol restricted products. Indeed, I'm grateful to the officer for saying that products were refused to be sold in test purchases. That shows positive action by the licensed holidays. Now, there has been some improvement made because you have again the photograph of the refusals log, which is this handwritten document. Perhaps not the best practice in the way that it's set out, and that has been improved because as of now, the company has a proper form which we've supplied to it so that it can log down the refusals of alcohol or other age-restricted products. From the handwritten document you can see, it sets out very clearly the date, the time, the product, the fact that ID wasn't used, that there were CCTV checks, and who it was that was on duty. Those are spelt out in the already existing checks that were carried out. So quite clearly something has been done and something is going right. The other thing that the business has been given and is implementing is this authority to sell alcohol. Now, much has been made of the fact that there is no paper trail to show that somebody has been authorised to sell alcohol on behalf of the premises licence holder or a DPS or anybody else that's got a personal licence. Well, there's a reason for that, and that is because the Act does not require a paper authorisation for anybody to serve alcohol or sell alcohol if they don't hold a personal licence. Now, what's happened is that things have improved on that, so there is this specific form which you have, which quite clearly authorises somebody to sell alcohol. So there is a paper trail that's going above and beyond the legal requirements. Now, I'm grateful to training centres for providing their information intelligence report, which is the other additional bits of paper that you've got included. And you'll see from those that these are anonymous reports. We don't know whether they are from a neighbour who's got an issue with the premises. We don't know whether it's a competing trader or there's nobody immediately next door. Sometimes, of course, with these sorts of problems, you find that there are competing traders next door. They try and dish the dirt, if you will, on their business next door to cause some mischief. But here, these reports are of the lowest value that could possibly be anticipated. It is no more than an allegation, and it has to be said in the context of the test purchasing that's been done, which has been shown, or which shows that the premises is successful in its challenge procedures. You've also got some photographs of the store to show the type of store that it is. It's a general purpose store that sells a number of different products, alcohol and tobacco being just one part of that offering, if you will. It is, however, an important part of the offering. It is, in my submission, not a bad premises in the scheme of things. It is a premises where perhaps there have been some errors of judgment or some lapses of judgment. That's perfectly understandable. Lapses of judgment and errors sometimes creep in for all the best of reasons. But those errors of judgment, in my submission, are really to do with two or three areas. The first is the buying process. Where have products been bought from? Clearly, those products that were the vapes should never have been put on sale. They were withdrawn from sale, and you've seen the evidence and you've heard the evidence where a test purchaser came in and on one occasion was told, no, we don't do that anymore. So there is action there, but the purchase process was probably somewhat faulty. I think it's fair to say they should never have been bought. Frankly, they should never have been sold either. And unfortunately, there are people in this country who sell these products completely unlawfully, and they will go around and they will target premises and try and achieve a sale with a legal product. And that is why there is a website set up so that retailers can check that the products are legitimate. And indeed, the company has got that information, is now checking that information. You will see the reference to the website also on the training standards letter, and that is important to make sure that it's done. But there are improvements that could be made in terms of keeping copies of receipts to find out exactly who it is that products have been bought from, making sure that only responsible retailers are the ones that sell these products or from whom the products are bought. Now, part of this revolves around one particular individual who is a member of staff selling products that they should not have been selling. And from Mr. Reader, you've heard that he bought products for his private use, for his friend, and they were sold by this member of staff. Now, that, to my mind, and I say this having been a licensing officer in an adjoining authority and indeed licensing manager in an authority, he's old. But the training of staff could have been better. There's no 2 points about that. How can that be improved? Well, it can be improved by staff undertaking a recognised training course. Now, how is that being done? Well, that is being done by using what is called the NAPOANS training. Now, if you've not come across this before, it is a restricted age product training course, which is put together by a conglomeration of licensing authorities, no, not licensing authorities, I apologise, training standards authorities in the Southwest, who have made this training package available at a cost, of course, to businesses across the UK. It's focused mostly on the Southwest, but it is a very useful package. And that package is now one that is being used at the premises to make sure that staff have got some recognised training to make sure that they know what the law is. It's really important that staff undertake that package and do so on a regular basis. Now, staff training, you've heard from Mr. Reader, was provided before, but it probably could have been better. So those are the processes that, those are the issues where there was a lapse of judgment or an error of judgment, but not in other matters. Clearly, this is not a premises that is involved in the massive smuggling of goods, of the import of tobacco. The number of products are relatively small. Now, I will address you on the points of law and the application of proportionality to all of this in summing up. But those are the points of evidence in essence that we want to give to you now. And of course, we're happy to answer any questions.
Right, thank you very much for that. Thank you.
Questions from the panel, does.
Right, does any member of the panel have got some questions?
I've got a question to Mr. Reader, if I may. How long have you operated the shop?
Nearly 5 years.
And did you have previous retail experience?
Not.
Thank you very much.
Any questions?
I'm fine with that.
Okay, okay. Does the license holder have any questions?
Yeah, that's us.
Does the license officer have any questions? Okay.
Have you?
We've got the licensing officer. It's somewhat confusing. Who's presented the report? We've actually got the licensing officer representing the licensing authority,
I see.
as well as the
So
applicant.
what am I saying?
So I believe Mr. Sharland probably
It
has
would be
some
Mr.
questions
Charland,
and
yeah.
I have some questions.
Trading standards.
Do you want me to go first?
Yes, if you've got any
Okay.
questions for the
Yeah.
license holder, please.
Yes. So Mr. Payne, you used the phrase there was no intention to deceive, no intention to hide in relation to Mr. Solomon showing the illegal tobacco to the officers. But just to clarify, he showed a portion of them. He did not show where the marble gold was, which was found by a detection dog, and he didn't tell officers that there was illegal tobacco in the storeroom. And bear in mind, the officer speaking to Mr. Solomon was an officer who'd just been in the premises and done a test purchase minutes before. So I just wanted to clarify that. The other point is, Mr. Payne, you said that these products aren't smuggled, and you also said that everyone makes mistakes, and unfortunately you have made a mistake there, because yes, it's legal for everybody has an allowance.
Chairman, I need to interrupt because these are actually statements that are being made rather than questions that are being asked.
I agree with that, yes.
Okay. I'll be able
Unless
to.
you want to rephrase it as a question.
Okay, I'll do that, and thank you. I apologise.
That's right.
So when a member of the public brings in non-duty paid product for their own personal use, that's non-duty paid product. But when that product then gets sold on to a third party, and then gets sold on in a retail, do you agree that that is then the definition of smuggled product?
Where something has been brought into the country in those circumstances, indeed, that is effectively smuggling, isn't it?
So do you agree that the products that we're talking about today are smuggled products, and is the correct term to use?
That's not for me to agree that or disagree with that. That's a matter of.
Okay, we'll agree
Thank
with
you.
that. We'll have, as long as we hear the exchange. So the applicant can carry on.
We've heard of the changes and the improvements that have been made. My question is, why is it taking a review to implement these improvements? Why didn't they happen following the interactions with the officers from licensing and training standards?
Essentially, I'm conscious that Mr. Reader is not a licensing expert. I'm conscious that he doesn't, you've heard his use of the English language, doesn't take necessarily all of the points that has been put out in the letter. But the fact of the matter is now he has taken action. And that's the important point in all this. It's not whether he did so in the past. We are now in a review. It's what action he's now taken to address the matter.
Okay.
And
Okay.
my final question is, you've described that the sales were a mistake by one member of staff, although that's contradicted in the evidence. But how did the member of staff know where these products were, what the price to charge? How did it come that they made these sales?
Yeah, I'm conscious we're getting into cross-examination, which of course is not permitted. But let me just deal with that particular point, because there is no possible way, because I'm not that member of staff, Mr. Reader is not that member of staff, there is no way of knowing the answer to that question. What we have said is that those sales were made by that member of staff. Now, what we don't know is whether, and there has been no evidence to show whether the money that was taken for those sales went into this gentleman's pocket or went through the tills.
Obviously, Mr. Reader is here as the premises licence holder, and he is the spokesperson for this. So it is legitimate for trading standards as the applicant to address questions either to yourself or to Mr. Reader. I don't think that does constitute cross-examination. They are legitimate questions being asked as a result of the presentation that you have made on behalf of Mr. Reader, and answers some of the presentations Mr. Reader himself.
And that's why I've given the answer to the question.
Have you got any further questions?
No, thank you very much for the opportunity.
Are you happy for Mr. French to ask
Straight to the end to ask any questions. Yeah, the licensing officer.
I think we are.
Right, here we go.
Mr.
Licensing
Brent.
officer, have any questions?
Thank you. I've got quite a lot of questions, and a lot of it is actually based on what Mr. Payne said, because again, I don't want to throw his words back at him, but he said people make mistakes. I think he's made quite a few in what he's misquoted me on, but I shall try and frame them as a question. Mr. Payne, do you agree that in relation to your comment about Mr. Reader not getting in touch But there was nothing in the letters that says you should get in touch. So at the bottom of page 102, it says, please can the above be rectified on or before the 21st of July? Once all of the above has been rectified, please contact me at the above email address so I can arrange a re-inspection. Do you agree that it says that?
If that's what it says in the letter. I don't think
I'll give you a chance to move down to the
I
bottom
don't
of that.
actually have page 102, so.
Well, it's the last couple of pages, the last licensing.
My number is slightly different, so I don't know whether it's different.
Yes, that's you.
95
Yes,
is on
that's
my
correct.
hard copy question.
Okay,
So yeah, there's just, I've had different
Yeah,
numbers working.
always happens, unfortunately.
Have you got page 95?
I have now, I've got that. No,
Yeah.
no, that's fine. It just proves my point, doesn't it? And it's what people make to say.
So I wasn't clear on the answer to my question. Do you agree that it says that? at the
Well,
bottom of that?
that's the evidence that's there in black and white. on
But
page
what you just
95.
outlined to the panel was not correct. Do you agree?
I've also just said it proves my point that people make mistakes.
The other matter you raised about the DPS, whilst I actually do agree with you that whilst the DPS is on the license, they remain the DPS unless they resign or there is a variation of DPS application. Would you not agree that someone who, shall we say, is, let's say hypothetically left the premises, how are they authorising new members of staff to sell alcohol?
My point there is that they don't need to, and that the authorization can come from somebody who holds a personal license.
Okay.
The law is not that the DPS has to authorize every sale of alcohol.
Now, I'm not saying the DPS has to do it. I'm saying a personal license holder can do it.
Yeah.
But where is the evidence to suggest that anybody was authorised during that period?
I think that is not for us to prove. It is a matter for the licensing authority to prove that there wasn't anybody. Our point is that there was, and as we know, there is now a DPS on the premises license.
Okay. You also stated that Mr. Reader was not present at any of the inspections. Which inspections were you referring to?
The inspections where tobacco was being sold.
Okay.
I believe he was present at the inspection where, no, he wasn't present at the inspection where the license was looked for.
He was present at on the inspection of the 11th of June, which is on page 94 and 95 or 101 to 102 on my pages, because he turned up at the end and had all of the issues relayed to him.
Yep.
Do you accept that's correct?
Well, that's what's in the letter, yes.
Okay. In your presentation and in your, I think in some of your responses to the panel and to Mr. Sharman, you make reference to a specific staff member who was in effect responsible for selling these goods. Do you accept that this particular staff member is still employed at the premises because his name appears in the refusal book in the additional information you provided on the starting from September? So he's still at the premises.
My instructions are that one of the individuals that was there is not working there anymore. The other one is.
Right. So
Mr. Solomon.
yeah. So Mr. Solomon, who was present on the 15th of March and who you have effectively blamed, Mr. Reader has blamed in his responses, is still working at the premises. Is that correct?
He is.
Okay. I have a question for Mr. Reader. If Mr. Reader is available to answer, entirely up to him. Can you tell me, Mr. Reader, what the 4 licensing objectives are? 4 licensing objectives. The ones that we all have to promote.
I think that's a question. I expect.
Well, Chair, what Mr. French has done is tried to lay a trap for Mr. Reader, who may well be the director of the company, but he is expecting Mr. Reader to come out with the 4 licensing objectives of protection of children from harm, health and public safety, prevention of public nuisance, and prevention of crime and disorder. Those are the 4 things that I know Mr. French is looking for from Mr. Reader, but it is the company that is the license holder. It's not necessarily something that Mr. reader can just cite off the top of his head.
Chair.
I think we can accept that Mr. Reader cannot, is unable to recite those. I think we keep talking about the company, and Mr. Reader is the sole director, as they're not anybody else. He is a controlling person in the company, as far as I understand.
And he's also the DPS responsible for training his staff.
Yes,
Personal license.
So the point is that he will have gone through that training and he will have learned what those licensing objectives are. I confess that I sometimes have moments, as I just did, trying to recite them, and I do this professionally day in, day out. The question is more to do whether those licensing objectives are promoted.
We'll move on to your next question.
Can I just come back on that slightly? That's that the licensing authority has to promote the licensing objective. The license holder has to promote the licensing objective. Mr. Reader, I wasn't expecting him to give me word for word. Just I've got to stop crime. I'm not allowed to sell to kids would have sufficed. That would, and because he's supposed to be able to train his staff in those licensing objectives, I think it's a perfectly reasonable question to ask whether he knows them himself. I don't think that's an unreasonable.
Well, that's fine. I'm conscious if that's what's asked for, and I'm sure Mr. Reader can give an outline of the things that he is supposed to do with the benefit of the license.
Well, the system objectives, new staff need to be training, for training, not allowed to do the consent sign, sell alcohol. Then we're not allowed selling underage 18, and then we're not allowed to drunk sell on alcohol like for some drunks or something like that.
That was all I was asking for. I'm not quite sure why that was an issue. My last question is, Mr. Reader, if you don't mind, why did you and Mr. Solomon both tell me that Mr. Solomon had only worked at the premises for 8 days when I attended in June?
Well, it wasn't Nardos, it was new staff, and you've been training that day.
You told me he was there for 8 days. We've
Yeah.
seen in the review paperwork that he was there on the 15th of March.
No, he wasn't there. He wasn't other staff. He was arriving quickly. He was at that he was working, but I let him off when he made a mistake. I think it was like trying to do something, and then I just get off the job, and then I'll give him Nardos a number.
Okay. Nothing further, Chair. Thank you very much.
Thank you very much for that. Okay, well, questions can't be tricky. If you can't understand them or whatever, to reiterate, fair enough, I take your point. It wasn't, as you point out, cross-religious questions, okay? All of they've got a nice level. So does any other party wish to have permission from the panel to put any questions to the speaker? No? Okay. Thank you. That concludes the presentation stage of this panel. I will now move into the final submission stage and ask each party if they wish to summarise their view before we go into closed sessions and make a decision. Would any party who has spoken like to make a concluding statement summarising their case?
Yes, please.
Yeah,
The
the applicant?
Yeah.
Yes, yeah.
No, not the applicant. The
Not
license
the
holder.
applicant, it's, no.
Is it the license? Is it the license holder you want to hear from, or the applicant?
Sure, that's all. Yes, yes, we'll hear from trading standards.
Thank you. Thank you, Chair. Put simply, you've heard our submission today. I think we've all accepted that the evidence shows that the premises was being used for the sale and storage of smuggled tobacco, and that sales were made. And we do agree with the licensing officer saying that holding a premises license is a privilege. We believe that too. We also believe it's important to work with businesses to give them an opportunity to improve. And I think we've demonstrated that that has been the case. We've heard what your sanctions are today. We've also heard deterrence is one of those considerations. Illegal tobacco is a huge issue nationally and in Oxfordshire. Similarly with electronic cigarettes. Indeed, the government today are announcing a raft of further tightening of the legislation around these two products because of the concern about them. If every time trading standards finds issues in these premises, there has to be a repeated visits, repeated advice, it's simply not going to protect the community because there are not enough officers available to do that in every premises of concern. Thank you.
Thank you. Right, what was the next one? Mr. Crunch. Liz, thank you.
Thank you, Chair. I would just like to conclude and say I don't think there's been anything said today during these during this hearing that would account for or mitigate the serious matters identified in Mr. Sharland's reviewed paperwork. The premises licence holder seems unable or unwilling to comply with the regulatory frameworks, be that licensing, environmental health, or trading standards. The licensing objectives and the promotion of them have been seriously undermined by the licence holder's actions or inaction, which has put public safety at risk. And the licence holder, the company of which Mr. Reader is a sole director, the DPS of the premises, are solely responsible for that. The licensing authority therefore fully supports the recommendation of the Trading Standards Service in asking for the premises licence to be revoked. That is consistent with the Secretary of State's guidance, to which I've referred to previously. And I'd ask that during your deliberations, you particularly take into account the paragraphs that I've mentioned earlier of the guidance, which are 11.10, 11.18, and paragraphs 11.24 through to 11.28. More generally, small businesses, local shops are important parts of local communities. Both myself and Mr. Sharland have stated today that our respective regulatory bodies both try and work with businesses, give them advice, guidance on corrective action where issues have occurred or non-compliance has been discovered, as do colleagues in other bodies such as environmental health, the police, etc., etc. However, they have to be a compliant business and willing to implement those corrective actions. They have to be safe businesses so that persons using them, including potentially our friends, our family members, our constituents, our local residents, are not put at risk by buying illegal, counterfeit, smuggled or mislabeled products. And they have to be businesses that are willing to implement best practice measures, particularly when dealing with age-restricted products. It is clear from the paperwork before you that has not been the case in this instance. The serious, repeated non-compliance and the alleged serious crimes are not a one-off. As per the last sentence of the guidance, paragraph 11.26, to which I've already referred, when making your determination, I would ask the steps be taken in the interest and safety of the wider community and not the licence holder, and would therefore say that the only way to safeguard local communities, our friends, our residents, and to promote the four licensing objectives is for the premises licence for 256 Ox Street, Abingdon, to be revoked. Thank you.
Thank you very much.
Thank you. Earlier on in the hearing, something was said about the criminal justice system and the relationship with the licensing scheme. The way that I sometimes think about this is that the criminal scheme looks backwards to issue penalties for what has happened with the aim of deterring reoccurrence in some cases. But licensing is about looking forward from this point and looking at what measures are required and proportionate, two really important words, to promote the licensing objectives going forward. Now, you know you have a number of options available to you, and one of those options that has been asked for is the revocation of the license. Now, if you're going to revoke the license, you need to be satisfied that it is proportional and reasonable, and in some respects necessary to do so in order to promote the licensing objectives. I would suggest that one way of looking at it is, would anything else suffice? could something else be put into place which would meet those licensing objectives and would ensure that they are promoted? Well, it's funny that I should say that, because there is some case law which of course refers to taking the least onerous option. And you'll be aware, I hope, of the East Side Cheese case, which was a case involving the Secretary of State for Health. And what that case said was, where there's a choice between several appropriate measures, recourse must be had to the least onerous, and the disadvantages caused must not be disproportionate with the aims pursued. Now, in this case, what we have here is a request for revocation, but also a suggestion that actually conditions might suffice. That's been provided in the application for review. And I'm grateful to Mr. Sharman for referring to the correspondence that we have had between us in terms of the conditions that would be legitimate, in my view, to attach to the license. I don't intend to go through a great discourse on proportionality and reasonability, because I think that serves no purpose. But what I would say is that it is helpful to look at a number of conditions and ask yourself whether those would promote the licensing objectives going forward. On one hand, we have the potential of revoking the license. What does that mean? That means that there can be no sales of alcohol at premises. Does it mean that there can be no sales of tobacco? No, it doesn't mean that at all. Tobacco sales can carry on. Does it mean that there will be no continuation of sale of vapes? No, those are not licensable. That can carry on as well. So revoking the license achieves nothing other than preventing the sale of alcohol. On the other hand, if you were to attach conditions to the license, those conditions provide a framework within which the license holder must abide. Now, you've not heard anything from the licensing department or training standards department about breach of license conditions of the license. You've heard about notices not being on display and whether the TPS data is there or not, but not breach of conditions. So to say that this is a company that is not willing to comply, to use those words that were echoed, is somewhat disingenuous. What we say is that the imposition of conditions actually has a real benefit here. And I've provided, and training standards have a copy of this as well, a number of proposed conditions. Let me just go through those with you and explain a little bit about that. Firstly, all store staff who are authorised to buy regulated products for sale at the premises, regulated products being those age-restricted products, so vapes, tobacco, alcohol, must be required to take all reasonable precautions and exercise due diligence in order to avoid buying illegal age-restricted goods. This will include, but not limited to, authorised staff responsible for the sale of products must be required to purchase only such goods from legitimate and established wholesalers who provide full receipts and at the time of delivery. Now, we explained there was one lapse of decision-making and judgment by buying these products from somebody who happened to chance buy. With this condition in force and the license continuing, that would not be capable of happening legitimately. B, the authorised buyer should ensure that all receipts for regulated products that are purchased include the following details: the seller's name and address, the seller's company details, the seller's VAT details, so that when inspections are made in the future, trading standards, licensing can ask to see these records and can verify that those products have been legitimately purchased. No license, no condition. 2, legible copies of invoices shall be retained, fairly straightforward. 3, staff working at the premises shall be instructed that if they become aware of any regulated products that are or have been offered for purchase, they shall inform the police or training standards. This is a whistleblower condition, if you will. Again, no license, no condition. Regulated products that are for personal use, and we've heard how products that Mr. Reader bought were intended for personal use must be clearly marked as such and stored in a designated area, so no confusion of mixing up with stock. Premises shall operate in accordance with the Challenge 25 scheme. Well, that's fairly standard condition if one could have standard conditions, and you will see that there's already compliance with that because there are posters up at front. Next, a refusals book will be maintained, and again, you've seen that there's a refusals book already, that's been improved with a form that's been provided. And then finally, that staff working at the premises, whether paid or unpaid, who sell regulated products shall receive training on the responsible retail of such products, and this training shall be repeated on an annual basis. So that is the general outline of what has been proposed. Keeping the licence in force and imposing those conditions provides a much tighter control over these premises, and also, frankly, lets each party know where they stand. Mr. Reader knows what he's got to do to comply with the law. It's all very well writing a long and intricate letter, commendable although that may be, but for Mr. Reader to go through that and work out the salient points and work out whether he's got to contact council or not is quite an onerous task. Putting it on the licence, it's there on the premises, it's in black and white on the wall, he can see what the conditions are. It is sensible, of course it's sensible that he goes through those and that staff go through those conditions that we propose on a regular basis. And of course that's required. Now, the conditions that we have suggested differ slightly from those that were volunteered or suggested by training standards, really to comply with the law on conditions about the fact that conditions should be self-contained, they should relate to a licensing objective. And I think you have the point already that this is not about necessarily selling vapes or tobacco. This is about the sale of alcohol and making sure that in conjunction with the sale of alcohol, the licensing objectives, particularly that of crime and disorder, are upheld. Premises has demonstrated that it can comply with the law through, for example, the test purchases. And that is the way that we say is the appropriate and sensible way forward. It's the intelligent way forward to maintain control of this particular premises, not result in a situation where a premises which should be part of the local community, which was the description used, potentially is put on the brink of not being able to trade because it cannot sell alcohol. Alcohol is obviously an important part of this business's offering to make it viable. So that is what we suggest in terms of the way forward. It is appropriate to add conditions. It will deal with those points and those lapses of judgment. The other thing to consider is that Mr. Reader, and through the company, has engaged in professional advice. He's done that at some significant cost to the company by having me here, by having my colleagues provide advice before the hearing. That can continue into the future, and hopefully that, combined with the enforcement visits, will make sure that the premises are on track and that they continue to uphold the licensing objectives. Now, I have to give one last word about the revocation. Quite clearly, the guidance is that you should seriously consider it, but that is not the same as you must revoke. It is you give consideration to it, but you weigh that up with all the other factors. And what we say in this case, with the offending being at the lower end of the scale in my submission, the licensing issues being relatively insignificant in the scheme of things, adding conditions on the license are by far the more weighty way of dealing with this problem, making sure that the business continues, and also imposing this thing. If they breach those license conditions, what will happen? Well, there's a very significant penalty waiting around the corner for failing to comply with those license conditions. If they fail to keep receipts of purchases made, there would be a significant financial penalty. And that penalty can include imprisonment. If there's no license, I've said this before, there would be no requirement to keep those receipts. There would be nothing for trading standards to look at. There would be no penalty. So that's why we say the weight is very clearly weighted towards imposing conditions rather than doing it. Chair, I hope that has been helpful to you in your deliberations. You have some submissions from me which reiterate those points to save you making copious notes. I hope that helps.
Thank you very much for that. Very detailed, covers everything. Right, let's see where I am, because I seem to be getting a little confused with regards to applicants, licensed officers and whatever. I think we're out.
I think yes.
I think we're down here, yeah?
I think I'm going to go and have a pee. It's really important.
That doesn't need to go in the minute.
Right.
I thought it worked.
Here we go. Would the applicant like to make a complaint about that? Should be quite told. You've done that. This is very, very important because we've got a lot of cross-talk and what have you. But we get to this point, it's really, really important. And could I invite all relevant parties to state they've had a fair opportunity to put their respective cases to the panel. I don't want people going out and thinking, oh, you know, I have conducted this, I think, poorly, with the figures coming up. But at the end of it, as long as you think or feel you've had a fair hearing, that's very important. Okay?
So I'm grateful for the time you've given.
Wonderful. Thank you. Thank you very much. Right, here we go then.
So, yeah, could we just confirm that you feel you've had the opportunity to say everything you need to say?
Yeah.
Thank you. Can we confirm that from the applicant as well? And
Oh, right, I should have been looking for people.
Sorry, just-
Sorry.
Okay,
No, it's
okay.
not just-
and licensing officer as well? You
Yeah.
Content.
I was going to ask Mr. Payne to clarify something, but if I'm not allowed to do that, then of course I'm very grateful for the time that the panel has given.
Okay, yeah, yes, I can sense some things. We will now make our decision, and this will be done privately with only members, the Democratic Services Officer and the legal officer present. If the panel intends to clarify any point, they may call all attendees back into the meeting. During this time, parties are asked to wait in the reception area, and they will then be collected and brought to the room when the decision is ready to be delivered. If any attendee is able to be contacted, the panel will, after reasonable attempts have been made, read the decision out and send an email to the applicant party with the decisions. Okay. Well, thank you. Thank you very much.
And yeah, I'm just touching some of the